Guys. In this video, we are going to talk about the part 1 of our constitution containing article 1 to 4, uh, which is the union and its territory. We are going to read about it. And let me clear one thing first, that I have created this channel to enhance my public speaking skills and to spread a word or two about law and our constitution and our legal rights. So please bear with me in beginning. And so yeah, here we go. Article 1, the name and the territory of the Union. Subsection 1, India, that is Bharat, shall be a union of states. Subsection 2, the states and the territory thereof shall be as specified in the first schedule. Subsection 3, the territory of India shall comprise A. The territories of the states, the union territories specified in the first schedule, and such other territories as may be acquired. And now we can say that Article 1 describes India as a union of states, although its constitution is federal in structure. The phrase union of states has been preferred over federation of states primarily because Indian federation is not a result of an agreement among states like American federation, and unlike American states, Indian states have no right to secede from union. India is called indestructible, India is called indestructible union of destructible states. I am learning with you too, so let's compromise on that one. Number of states and union territories in India. Earlier in India, there were 29 states and 7 union territories, but after the abolition of Article 370 in the year of 2019, there are only 28 states and 8 union territories in India. The state of Jammu and Kashmir is now bifurcated by the Jammu and Kashmir Reorganization Act 2019 with effect from 31 October 2019. Remember this date, it's very important in current context. Into two union territories, that is Jammu and Kashmir and Ladakh, and also the union territories of Daman and Diu and Dadar and Nagar Haveli has been constituted as one union territory through the enforcement of the Dadar and Nagar Haveli and Daman and Diu Merger of Union Territories Act 2019. India, that is a union of states in automobile transportation. Rajasthan versus State of Rajasthan, AIA 1962. The Supreme Court said that the Union India is a union of states, and while interpreting the constitution, one must keep in view the essential structure of a federal or quasi-federal constitution. That is, the units of the union also have certain powers of the as the union has. See, primarily you will find many case laws in my readings because I am a student of law at Campus Law Center, Delhi University. So we are taught by the basic methodology of case law. So uh, I think it's better for you to learn the case laws and remember the things stated by the Supreme Court itself. It will be beneficial for you in your judiciary exams, in your UPSC exams, as it is the bare act and the language of the Supreme Court judges itself. So I hope it shall find you good. And now talking about the nature of Indian Constitution, federal, whether federal or not. The Constitution can be broadly divided into two kinds depending upon the relationship between the centers and states. Where the powers are divided between the central and state government, then it is called federal constitution. Example, USA. And if powers of government are centralized in one form of government, that is the central government, only then it is called unitary government. For example, UK. Some of the essential features of federal constitution are division of power between central and state government, written constitution, rigidity of constitution, meaning thereby that it cannot be changed unilaterally either by the central or state government, supremacy of constitution, impartial judiciary, and bicameralism, etc. Indian constitution has all these features, so it can be described as a federal constitution. However, some renowned jurists have characterized it as, remember these points, it's very important. KC Biere calls it quasi-federal. He says that India is a unitary state with subsidiary federal features rather than a federal state with subsidiary unitary feature. Ivor Jennings opines that India is a federation with a strong centralizing tendency. Austin describes John Austin, the father of jurisprudence, English jurisprudence. John Austin describes it as cooperative federation. Professor Alexandrovich and D.D. Basu describe it as a federation sui generis. In State of West Bengal versus Union of India, AIA 1963, it was stated by the Supreme Court that Indian Constitution is not truly federal. It was stated by the Supreme Court that Indian Constitution is not truly federal. In State of Rajasthan versus Union of India, AIA 1977, the Supreme Court held that Indian Union is a federal, but the extent of federalism is largely watered down by the need of progress and development of a country which has to be nationally integrated, politically and economically coordinated, and socially, intellectually, and spiritually uplifted. In Kuldeep Nair versus Union of India, year 2006, the Supreme Court said that it is pseudo federation of amphibian character. It changes character, that is, the meaning of it is that it changes character from federal to unitary at times, like in case of national emergency. Article 2, thereby admission or establishment of new states. Parliament may by law admit into the union or establish new states on such terms and conditions as it thinks fit. Article 2 states that Parliament has two powers. The Parliament, the number one, the power to admit new states into the Union from foreign territory, which may be done by acquisition or annexation, and the power to establish new states, state which cannot was not in existence before. Article 2A, Sikkim to be associated with the Union, which was omitted by the Constitutional 36th Amendment Act 1975. Prior to 1947, Sikkim was a princely state, and after the lapse of British paramountcy, Sikkim expressed its desire for association with India. As a result, Article 2A was inserted in 35th Constitutional Amendment Act 1974 to make Sikkim an associate state of India. In 1975, the Prime Minister of Sikkim appealed to the Indian Parliament to make Sikkim a state of India. Accordingly, through the enactment of 36th Constitutional Amendment Act 36th Constitutional Amendment Act 1975, Sikkim was added as a full-fledged state of the Indian Union, and Article 371F was also inserted in the Constitution, which provides for special provision with respect to the state of Sikkim. Now we come to Article 3, formation of new states and alteration of areas, boundaries, or names of existing states. Parliament may, by law, A. Form a new state by separation of territory from the Union. Um, Formation of new states and alteration of areas, boundaries, or names of existing states. Parliament may, by law, A. Form a new state by separation of territory from any state or by uniting two or more states or parts of states or by uniting any territory to a part of any state. B. Increase the area of any state. C. Diminish the area of any state. D. Alter the boundaries of any state. E. Alter the name of any state. Provided that no bill for the purpose shall be introduced in either House of Parliament except on the recommendation of the President, and unless where the proposal contained in the bill affects the area, boundaries, or name of any of the states. The bill has been referred by the President to the legislature of that state for expressing its view thereon within such period as may be specified in the reference, or within such further period as the President may allow, and the period so specified or allowed has expired. Explanation 1. In this article, in clauses A to E, state includes a union territory, but in the proviso, state does not include a union territory. Explanation 2. The power conferred on Parliament by Clause A includes the power to form a new state or union territory by uniting a part of any state or union territory to any other state or union territory. This was the bare language of Article 3. Now, Article 3 talks about the formation of a new state out of the territories of the existing states. Article 3 authorizes the Parliament to make laws to increase or decrease the area of any state or alter the boundaries or change the name of any state. The conditions laid down for making such a law are: first, no bill for the formation of a new state or the alteration of boundaries or the alteration of name of the existing state shall be introduced in either house of the Parliament except on the recommendation of the President. Secondly, if the bill affects the area, boundaries, or name of the state, then the president is required to refer the bill to the legislature of that state so affected for expressing its views within the period specified by the president. And by talking to you in the meantime, I have realized that I am getting better at speaking English and getting more confident. So thanks, thanks to listening to this. If you are up to here, thank you. Thumbs up for your dedication. The president may extend the period specified. If the state legislature fails to express its opinion within that time limit, it shall be deemed to have expressed its opinion. The parliament is not bound to accept or act on the views of the state legislature, even if the state had submitted its view within such period of time. This procedure is not required to be followed in case of union territories. Such a bill needs to be passed by simple majority, and no guarantee of territorial integrity of a state. That was said by in Re Barubari Union and Exchange of Enclave, AIR 1960. The Supreme Court stated that the Constitution of India does not guarantee the territorial integrity of any state of the Union of India. And reference of bills to state in Abulal Parathe versus State of Bombay, year 1960. Supreme Court observed that if the state legislature to which the bill has been referred does not express its view within the period so specified or extended, the bill may be introduced in the parliament even though the view of the state has not been obtained by the president. Further, it is not necessary to make fresh reference to the state legislature every time an amendment to the bill is proposed and accepted. Cession of Indian territory to a foreign state. In reference by the President under Article 143 AIR 1960, the Supreme Court held that the power of Parliament under Article 3 to diminish the area of any state does not cover ceding of Indian territory to a foreign state. Such cession could only be implemented by an amendment of the Constitution under Article 368. This was the question which came into our third semester examinations. It was the first question of the first paper, Constitutional Law 1, in our semester exams. And yes, I wrote the case of Ray Baruwari Union. And now we come to the point of settlement of boundary dispute. In Magan Bhai versus Union of India, year 1969, the Supreme Court ruled that settlement of boundary dispute between India and Pakistan does not involve cession of territory between India and Pakistan, does not involve cession of territory, and such settlement does not require constitutional amendment. It could be implemented by the Government of India under its executive power. India Bangladesh Land Boundary Agreement 2015, I remember. The Constitutional Amendment 100th Amendment 2015 deals with exchange of certain enclave territories with Bangladesh and conferment of citizenship right to residents of enclaves consequent to signing of Land Boundary Agreement 1974 between India and Bangladesh. This happened recently in the Sheikh Hasina regime, who is now uh, whose government is now thrown away out of the power from Bangladesh. If you are updated with the news, she is residing currently, has taken a reside in India, and we are looking after her as she is daughter of Sheikh Muzabir. I don't remember the name correctly, but he was the founding father of Bangladesh. He Sheikh Mujibur Rahman. Yes, yes. You'll learn about it. We'll read about him someday soon. Article 4 laws made under Articles 2 and 3 to provide for the amendment of the first and fourth schedules and the supplemental, incidental, and consequential matters. Subsection 1 any law referred to in Article 2 or 3 shall contain such provisions for the amendment of the first schedule and fourth schedule as may be necessary to give effect to the provisions of the law and may also contain such supplemental, incidental, and consequential provisions including provisions as to representation in parliament and in the legislature or legislatures of the state or states affected by such law as parliament may deem necessary. Subsection 2 no such law as aforesaid shall be deemed to be an amendment of this constitution for the purpose of Article 368. And while speaking this, I have realized that I have a problem in speaking SH. That is in my name itself, Utkarsh. But it's still, I can't speak S clearly. Maybe it's because due to my formation of my teeth. Let's hope it will get better. The note of this article is when a new state is admitted or established, or a new state is formed, or area, boundary, or name of the existing states are altered, the parliament may by law make all the consequential and incidental changes in the constitution by law making procedure, and an act of the parliament for the aforesaid purpose will not be deemed to be an amendment of the constitution for the purpose of article 368. It means that the procedure established by Article 368 is not required to be followed in such cases. Sayonara. Thank you. To Article 4, we have done. We will continue to Part 2, citizenship in the next video.